Well, good morning. My name is Chase McDonald. I'm an assistant regional engineer in the Utah Lake Jordan River region. Thank you for being here this morning. If you guys are anything like me, even though it's a beautiful day outside, you'd much rather be in here talking about water rights. So I'm covering a topic today that we get a lot of questions about, water rights versus water shares. There seems to be a lot of confusion, so please, at any time, if you have questions, jump in, let's clear them up, because this can be pretty confusing. So right off the bat, we'll talk about water rights. So water rights in the state of Utah are considered real property created within Title 73 of the Utah Code. They entitle the owner to divert and beneficially use water within the limits of the water right. They are appurtenant to the land. You can also say kind of attached to the land. And the ownership transfers with the land unless severed. And a lot of people don't realize the county recorder is actually the office of record of ownership for perfected water rights. So I put a little house there just to show that, like, when we say the water is appurtenant, we mean that if you sell your land, typically the water transfers with it. A water right will typically transfer with the land, unless you explicitly reserve it in a deed when you convey the property. A pretty easy way to tell if you have a water right versus a water share. If you have a water share, you typically pay an assessment. If you have a water right, you just own it, and even though it's considered real property, to my knowledge, the government doesn't tax it. So we'll keep that between us, because if they find out, they will start taxing it. But moving on, so that's water rights. You own it, or an entity owns it. They have the right to use it within its limits. A water share is a little bit different. So a water share, there's a water company or an entity that owns the water rights. And then they divide it into equal interests and sell the shares of stock. So I have a little RV there. You can think of it as the company owns a fleet of RVs and you just rent one. You can think of it kind of as a rental. So you own a stock in that company, but you're paying that company to use it, paying an assessment. But it entitles the shareholder. If you own a share of stock in a water company, you are entitled to use the proportionate share of water in the water company within the limits of the company's water right. So if you own the share, you can use it within what the company's base water rights are approved for. They are not appurtenant to the land. That's another reason I have an RV there. They're kind of mobile. And if you move, like if I own a share in company A and I decide to move, I sell my property, that water share is not attached to that ground, so it doesn't transfer by appurtenance. So if I wanted to sell my property and include that water share in that sale, I could sell that share to the new owner. They would go to the company would reissue a share of stock in their name. That's how ownership transfers work. And the company keeps records of that ownership, who owns what shares. So like I said, a water right, somebody owns it and is able to use it. A water share, a company owns that water right. You get a share of it, and you pay an assessment to use that water. Let's say if I own a share in a company and I want to use that water somewhere else outside the limits of the company's water right, I can do so, but I have to, there's a few steps. I like to think of it as a three-part process to be able to use the water outside of what the company's water right is approved for. And we'll go over the rest of the presentation. We'll be going over those steps. The first step is to prepare a change application based on your share of stock, and then submit that change application. Step 2 is to submit that change application for review to the company. And then after they sign off on it, after they approve it, the third step is to file the change, use the water, and work toward certificating that water share. So the first step, going back over that, the first step is the applicant's responsibility. And the first step is to prepare a proposed change application. Before you can do that, our office needs documentation that you own a share in that company. So what a shareholder would do is provide a copy of their stock certificate in that company to us. We will issue what's called a share statement, which just defines the limits of that water share, just what it's good for, the beneficial use, place of use, all those types of things. And then we will create what we call just a water right jacket for that share. And keep in mind, that doesn't mean it becomes a water right. It's still a share. We just create a water right number just for our own bookkeeping purposes. It's still a share. The company still owns that right. But for our bookkeeping, we create a water right jacket for it. So once that is done, then we can help prepare a proposed change application based on that stock. And then it is on the applicant to provide, to deliver that proposed change application to the company for review. And that delivery, this will come up later, but when the shareholder delivers that proposed change application, there needs to be documentation that they delivered it. There needs to be some kind of receipt saying that they provided that proposed change application to that company on this date. Like I said, that'll come up later. But at that point, the applicant can cooperate with the company to prepare and or correct that proposed change application. The proposed change application needs to include the certificate number of the stock in the company, a description of the land proposed to be retired from irrigation, and that's if that share is based on irrigation. And just a quick side note, some of the confusion that we see is people say, well, if you take water from this company and move it over here, does that reduce the company's water right? No, it doesn't. What we do is we take some of their use out of production for it to be used over here. The company still owns it, and sometimes in the condition of approval of the change applications, maybe they won't be delivered quite as much water, but they still own that water. If that change application lapses or is withdrawn, that company still owns it. So that's just a little side note that we get a lot of confusion with that. But going back to the presentation, so the proposed change application needs to include the certificate number for the stock, a description of the land proposed to be retired, an agreement by the shareholder to continue to pay all applicable corporate assessments. Like I said, you're just have a share in that company, so you're paying that company an assessment to use that water, and that doesn't change when you file a change application. And then any other info that the water company may need to review that change application. So that's, in my mind, that's step one, the applicant preparing, getting a share statement, preparing that change application, giving it to the company for review. The second step is for the company to review that proposed change application. Now, the company, by statute, has 120 days to respond in writing to that proposed change application. That's why I was saying you need to get documentation. If a shareholder submits a proposed change application, they need to get documentation because the company has 120 days to respond. So we need documentation of what date that company was informed of that change application. The company has three different options. They can consent to the change application, which basically they'll usually just sign it and send it back to the shareholder. They can consent subject to conditions, or they can decline consent, but they need to describe their reasons. If they do not respond within 120 days, we just deem that consent. And in that case, the shareholder can just provide an affidavit to us saying we gave the company the proposed change application on this date. It's been 120 days. I want to proceed forward and file this change application. But when the company reviews the change application, the proposed change application, they can consider whether it will increase their costs, whether it'll interfere with their ability to manage and distribute water. They can look at the quantities of water and see if that fits within the share that shareholder owns. Make sure that they're not trying to change more water than what their share is worth, and see if it'll impair quantity or quality of water, including carrier water. They can also check to make sure that the proposed change application doesn't violate statute, if they can retire the uses that are in the heretofore that change application, or things of that nature. They, as it says here, they may not withhold consent if the issue can be reasonably mitigated without cost to the company, and they can require additional costs within reason to the shareholder. And if, another little side note, if they can't come to an agreement, sometimes it can move to litigation and be settled in a court to move forward with that change application. So that's step 2, is the company reviewing that application. Then step 3, the applicant, once they get consent or once that 120 days passes, they can file that change application. And so the change application must include shareholders' authority to file. So that's, like I said, either the consent of the company, sign off by the company, or a court order, anything of that nature. And then at that point, the shareholder, like I said, files that change application. Then once that change application is approved, they can use that water as approved in the change application. And at that point, they do not need the company to be involved if they file extensions on that change application, and they can, or for certification. So I think that's about the end of my presentation. Just to clarify again, so there are water rights. Those are owned by the water user. They don't need any. They don't pay any assessments. They own that. They can use that water right for what it's been approved for. Water shares, a company owns the water rights, and then they sell shares. Basically, you can think of it as they rent out that water to their shareholders. You pay an assessment for the ability to use that company's water rights. And then if you own a share in a company, you can file a change application to move it outside of what the company's base rights are approved for. And that's the process that we just described there. So at this point, take these questions for what they're worth as you're studying. Take it as a hint, if you would. At that point, are there any questions? Anything that needs clarified? No? Yes. Okay, we wait for the mic.
Thank you. I've seen applicants, instead of demonstrating, showing land that will be retired, they just say, I've sold my shares, the company can no longer deliver this water, and so it is therefore retired because I don't own the shares. And I was curious what the division's view of that argument is.
So you're saying that is for a change application in lieu of saying this is retired, they just say I've sold this?
So yeah, so I guess the criteria asks that you demonstrate, so for a share used for irrigation, that the applicant retires the land from irrigation so that it's no longer used, and instead of saying here's a picture or a description of the parcel that's retired, they just say, well, I don't own these shares, so surely I can't be irrigating that same land.
I'm not sure I'm totally following, because in my mind, if they don't own any shares anymore, I'm not sure why they would be needing to retire land anyway.
Okay, that makes sense. Thank you.
Good morning. I have a question about, let's say I own a certificate from an irrigation company, and the irrigation company dissolves. That certificate is a share of a water right. But without the irrigation company in place, does that certificate is still valid or is null and void? That's
Is that something that's happened to you?
yes. No.
Okay, because I haven't heard of that happening. I feel like that would be kind of a case by case basis, because if the company dissolves, maybe somebody bought the base water rights from them, in which case you may take it up with the new owner. You may, I mean, it is, you're not an owner of that water right, so if they sell that water right, I'm not sure if there's much you could do. What I would suggest in that case is contact one of us and contact our office, and one of us will look into your specific case and try to come up with an answer and let you know what the status of that is.
Water companies are just that. Still not working. And water companies are just that. They're companies incorporated under the laws of the state of Utah. If the corporation is dissolved, there's a winding up process that's specified in the law. And as part of that winding up process, then all their assets and their liabilities are cleared up. And then the shareholders are entitled to whatever is left after that process. And so if the corporation is in that position, then you, of course, want to be very involved because you are a shareholder in a corporation that's being dissolved, and you're entitled to whatever comes out of that dissolution. And, well, there's a statutory process that talks about how it's done. But what happens is sometimes those corporations dissolve and say they're no longer doing business, and they just sit there, and nobody ever follows the process to actually get the winding up actions completed. And so if you're in that position, I'd get legal assistance and find out what's going on and work through that. Because they may for a time, as shareholders, honor the shares and work together to distribute the water, but there's a corporate action either pending or going on, and you want to be involved in that because that's where the water rights will be dealt with.
Okay, thank you, Boyd.
Now, this is a more basic question. We talked about water rights as something an individual owns, or I guess a company could own it. But if I'm a landowner and I own the actual water right, it's my water right with that land. Now, we talked yesterday about an acre foot, and that is a standard measurement. Now, is there correspondence? If I own one water right, do I own 1 acre foot? If I own 10 water rights, do I own 10 acre feet? Is there a definition of exactly how much volume a water right encompasses?
So, not as you described it, no. A water right is limited by its beneficial use. So if you, so it's based on your beneficial use. If you own a water right in a certain area for a certain amount of acres, it could have a different volumetric, a different acre foot amount than if you were in a different area. There are different duty values. So the way we come up with the acre foot values is we look at what the beneficial uses are, we look at that duty in that area, and then calculate it from there. So it's not just one water right equals 1 acre foot or something like that. It's whatever that water right is approved for, whatever its approved beneficial uses are.
All right, so if I'm asking for water rights to appropriate them, what do I use to calculate to know exactly what I need to ask for? Do I just say, okay, here I need 10 to irrigate, to do the domestic, and to do the livestock, I need 10 acre feet. So that'll all be one water right if it's approved.
It could be, yes.
Okay.
And to answer your question, how do you determine that? We have the duties of the beneficial uses on our website, or you're always more than welcome to call in and ask somebody, and we're more than happy to help you out.
As Chase mentioned, it's all based on the beneficial use of the water, so, and the duty where the water is. So you had 10 acres of irrigation and you're a 4 acre foot per acre duty, that's 10 times 4, so you'd need 40 acre feet to do your 10 acres. And then the numbers of animals, the standard usage for a cow or equivalent is 0.028 acre foot per unit. So you figure out how many animals you have and you multiply that by 0.028 and add that to your 40 acre feet, and that's how much you need for a water right to do your beneficial uses. So it all gets back to what you're going to use it for. So you don't just pick an acre foot number and say that's what I'm going to do. You have to look at your beneficial uses and see what the requirement is of those beneficial uses, and then that's how you make the determination. Okay.
I had a question about, I've been told that if a municipality purchases a water right or obtains a water right, they cannot sell that once they have it. Is that true, and is that the same for a share? If a municipality owns shares, can they sell shares off and or lease?
So you're correct. When a municipality gains a water right, or, and correct me if I'm wrong, Kent or Boyd or somebody, but if a municipality comes in possession of a water right or a water share, they cannot divest themselves of the water rights or the water shares.
Okay. Can we lease?
I believe that would be similar to divesting. Is that correct, Boyd or Kent? No.
There is a constitutional prohibition for municipalities of divesting themselves or leasing or conveying away water rights or water works that they have in their system. And so they cannot do that. There's actually some legislation this year that was passed that's going to go to a vote of the general election to amend the Constitution. That'll be coming up in another year and a half. I think it's be the 2020 election, to actually revise the Constitution to allow municipalities to be able to lease or contract for their water within their service area. So they're going to be able to, it's going to clear that up, and it's going to be a good thing. So the legislature worked through that this year, and I think that's a good amendment to that. The other thing I want to say is water shares in a water company are a little bit different because it's not a water right. It's just the right to use. And so there's some questions about that, about whether those shares can be conveyed or not. Is that, I mean, that's the way I understand it. So it's a little confusing. The constitutional amendment, I don't think it addresses water shares, so that's not going to be cleared up with this constitutional amendment. So my guess is, because it's not clear, that water shares probably could be conveyed, but water rights themselves cannot be by a municipality. And that's not for all public water suppliers, because public water suppliers can, but if you're a municipality, you're constitutionally prohibited from divesting yourself of that water. So.
Okay, thank you.
We have a question from Cedar City.
Okay.
Can a shareholder sell the water after a change application is approved?
Yes. Yes, they can. Okay.
Is there any, say, an organization owns shares and has so many allotted acre feet, and they don't use those full allotted acre feet in the year? Is there any chance of them losing that allotment?
So, to my knowledge, if they own shares and they're not using their full allotment, the company's water rights, the actual water rights themselves, will not be in jeopardy of being, I guess, having partial forfeiture. And I could be mistaken on that. I think I'm saying that correctly. No? Not sure. Boyd, feel free to chime in if...
I missed part of the question because I was talking to
Oh,
Paul.
okay.
But if you're talking about whether water companies are subject to forfeiture, the answer is yes.
Say a company has shares through Weaver Basin, and they have 500. Thank you, sorry. Say a company owns so many shares through Weaver Basin, and they have, say, 500 acre feet allotted to them, and they only use 250 of those 500 acres. Does the person using the shares through Weaver Basin stand to potentially lose those shares?
Well, I don't think you mean Weber Basin because they don't sell shares.
Okay, well then I guess maybe I'm confused on that. So I work for an organization that we pay so much every year to Weaver Basin, we get so many allotted acre feet.
So that's an exchange.
That's an exchange.
Yes.
Could you explain the difference maybe between a
So
share and
shares,
exchange?
so share is corporate stock in a company. And so as a stockholder in that company, you're entitled to an equal portion of the dividends, is the way you can think of it, which is their water. And so as a shareholder, then you can use that water as a shareholder. An exchange is an arrangement where you enter into a contract with Weber Basin, or that's the way Weber Basin's exchanges work. And they agree to provide so much water for a certain amount of money that you pay to use the water. So if you don't use it, they just use it other places.
And that's what I figured, but as we implement more conservation, we're not, as long as we continue to pay and have the same contract, we're not in any way gonna potentially lose those.
Well, it depends on the terms of the contract,
Yeah.
but I presume their contracts don't penalize you for not using it.
Gotcha. Thank you.
And just to clarify kind of what I was thinking of it differently. A water company, if they don't use all of their water, they are definitely subject to forfeiture. What I thought you were asking is if a shareholder files a change application and moves their water over here, but they don't use fully their full allotment over here on that change application, I don't believe that the company's base water rights would be at risk there. And maybe I'm mistaken on that, but that's what I thought you were asking. But thank you, Boyd, for clarifying there.
And Chase, by statute too, I mean, it's beneficial use again. An irrigation company is required to use their water to its full beneficial use. If the company isn't using that, if you're a shareholder in a company and you're not using your water right, and the company can't come back and show that they're using all of their acreage to irrigate on, there may be a court action or through the adjudication process, a restriction of then what the company can do. Statute says a company can come back then and assess that forfeiture or non-use penalty to those shareholders who are not using their water. So that by statute, they can come back and say, you know, the company's right is being reduced and it's because you weren't using your water, and therefore we're going to assess that non-use to you, and that your shares are no longer going to have water if there is a court determination that it's been forfeited.
Okay, and that makes sense. Does that make sense to you all? Right, any more questions? Doesn't look like it. Okay, well, thank you for your time. Like I said, if you have any questions, please don't hesitate to contact our office. And if we can't answer your question right away, we'll do what we need to get to the bottom of it. So, thank you.